I'm Jameel Jaffer. I'm director of the ACLU's National Security Project. The ACLU is challenging the new surveillance law because it allows the government unprecedented power to monitor the communications of innocent people. It doesn't provide the kinds of safeguards that the Constitution requires. It gives the government the power to engage in dragnet surveillance of international communications, emails and telephone calls between people living in the United States and people abroad. The lawsuit involves a challenge by a coalition of organizations, human rights organizations, reporters, media organizations, humanitarian organizations, legal organizations, all of which share one thing in common, which is that they value the confidentiality of their international communications.
I'm Dinah PoKempner. I'm the General Counsel of Human Rights Watch. Human Rights Watch joined this suit because secure communications are vitally important to our work. We can't really work and get the facts on human rights abuse without being able to talk to people in confidence. We can't do this work if no one will talk to us because they think our communication lines are insecure.
Chris Hedges is a contributor for The Nation magazine. He has worked in war zones all over the world. He previously wrote for the New York Times.
The ability of the government to monitor private communication, especially of journalists, is one that makes the practice of journalism ultimately impossible. The ability of us to assure our sources, who often speak to us at great personal cost, that they are secure, is what allows them to talk.
We've had situations where very unexpectedly we'll be summoned into a diplomatic office and challenged on something that we had not made public, and then you have to wonder, where does that happen? Where was the leak?
It is a reasonable supposition that somebody such as myself, who writes frequently on Middle Eastern affairs — I spent 7 years in the Middle East, I'm an Arabic speaker — would indeed be monitored, especially because I have overseas contacts.
When our communications are intercepted, we don't know to whom they go. It might be to the U.S. government, but it might also be to the very governments we're reporting on, because there are security relationships between them and the U.S. government.
The original Foreign Intelligence Surveillance Act required the government to obtain a warrant from a court inside the United States whenever its surveillance activities, its foreign intelligence surveillance activities, implicated the rights of U.S. citizens or U.S. residents. There were also protections for the communications of innocent people. A lot of those protections have been weakened by the new law. Some of them have been removed altogether.
None of us, especially those of us who have covered intelligence communities, are denying the necessity of monitoring. What we're asking for is that it's done through legal channels and that there are safeguards in place.
While we want to help, any kind of a criminal prosecution, and we're not in the position of resisting legitimate law enforcement, we don't want to endanger people around the world, either our own researchers or dissidents or other activists. And so some limitations, some judicial oversight is very important here.
What we need is a surveillance law that allows the government to target communications of people who are actually suspected of having done something wrong. We don't need a surveillance law that allows the government unfettered access to the communications of millions of innocent people.